Okay, so this is Daf 31 of Shevuot, which is for May 1st. This is Sunday, May 1st, 2025. And I ended Daf 30. I read into 31, but I'll just continue. I'll start at 30 and go into 31 now. So from where is it derived that a case where a judge who knows that the witnesses testifying before him are lying, even though he is unable to prove it through the cross-examination with regard to the verdict, the result will be that it is fraudulent. That he should not say, since the witnesses are testifying and I cannot prove their deceit, I will decide the case based on their testimony and now we're in 31, and let the chain or collar of culpability for the miscarriage of justice be placed around the neck of the false witnesses. It is derived, as the verse states, quote, distance yourself from a false witness, which is Exodus 23, verse 7. So the Gemara provides a mnemonic for the additional halachot derived from the verse, distance yourself from a false witness, or a false matter. 3 relating to a student, 3 relating to creditors, and 3 relating to a judge. Rags, hears, and explain. So, from where is it derived with regard to a student who is sitting before his teacher and sees a claim that provides advantage for a poor person and disadvantage for a wealthy person, that he shall not remain silent? It is derived, as the verse states, distance yourself from a false matter. So from where is it derived with regard to a student who sees his teacher who is erring in judgment, that he should not say, I will wait for my teacher until he concludes the trial, and then I will contradict him and construct a ruling on my own so that the verdict will be attributed to my name? It is derived, as the verse states, quote, distance yourself from a false matter. From where is it derived with regard to a student whose teacher said to him, you know concerning me that even if one were to give me 100 times 100 dinars, I would not fabricate a claim. Now I have 100 dinars in the possession of so-and-so, and to whom I lent money, but I have only one witness of the 2 required to testify about the loan and enable me to collect payment. From where is it derived that the student will not join with other witness and testify? It is derived, as the verse states, quote, distance yourself from a false matter. The Gemara asks, is it from the verse, distance yourself from a false matter, that this matter is derived? But isn't he certainly lying in that case? And this is already stated, as the merciful one states, quote, you shall not bear false witness against your neighbor, Exodus 20, verse 13. Rather, the reference is to the case where the teacher said to him, it is certain that I have one witness, and you come and stand there beside him and do not say anything, as in that matter you do not express a lie from your mouth. Your silent presence will create the impression that I have 2 witnesses and lead the debtor to admit his debt. Even so, it is prohibited to do this. Due to that which is stated, distance yourself from a false matter. So there are 3 halachot with regard to a creditor. From where is it derived with regard to one who is seeking repayment from another of a debt of 100 dinars, and there is no witnesses to that effect, that he shall not say, I will claim that he owes me 200 dinars, so that he will admit that he owes me 100 dinars, and he will become liable to take an oath to me, the oath of one who admits to part of a claim, and on that basis I will extend the oath and compel him to take an oath with regard to a debt that he owes me from another place. It is derived, as the verse states, quote, distance yourself from a false matter. From where is it derived with regard to one who is seeking repayment from another of a debt of 100 dinars and claims that the debtor owes him 200 dinars? I said, yeah, no, this is the same thing. It seems like the same thing. I will completely deny his claim in court, and I will admit him outside the court, so that I will not become liable to take an oath to him. He will not extend the oath and compel me to take an oath with regard to a debt that I owe him from another place. It is derived, as the verse states, distance yourself from a false matter. Okay, from where is it derived with regard to 3 who are seeking repayment from one individual for a total of 100 dinars, that one of the 3 should not assume the role of a sole litigant and claim 100 dinars, and the other 2 will assume the role of witnesses so that they will exact payment of 100 dinars from the debtor and divide it among them? It is derived from the verse states, distance yourself from a false matter. There are 3 halachot with regard to a judge. From where is it derived with regard to 2 individuals who came to judgment, one dressed in rags and one dressed in a raiment worth 100 times 100 dinars, that the judges say to the wealthy person, dress like the poor person, or dress like the poor person in a garment like yours? It is derived, as the verse states, distance yourself from a false matter. The Gemara relates, when individuals would come before Rabba bar Rav Huna for judgment, he would say to them, remove your fine shoes and descend for judgment, so that you will not appear more distinguished than the other litigant. From where is it derived that a judge should not hear the statement of one litigant before the other litigant comes to court? It is derived, as the verse states, distance yourself from a false matter. From where is it derived that a litigant shall not explain the rationale behind his statements to the judge before the other litigant comes to court? It is derived, as the verse states, distance yourself from a false matter. Rav Kahana teaches that this halakha is derived from that which is written, quote, you shall not accept, or lo tisa, a false report, Exodus 23, verse 1, which he interprets as though it is written, you shall not cause others, so lo tasi, to accept a false report. The verse states, and did that which is not good among his people, Ezekiel 18:18. Rava says this is referring to one who comes to court with authorization to present claims on behalf of another. And Shmuel says this is referring to one who purchases a field concerning which there are those who contest ownership of it, as in that way he involves himself in the dispute of others. So the Mishnah teaches that the oath of testimony is practiced with regard to those fit to testify. The Gemara asks, this statement serves to exclude that person not allowed to testify who was not mentioned explicitly in the Mishnah. Rav Papa said, it serves to exclude a king who, although he is neither a relative nor otherwise disqualified from testifying, does not testify in court. And Rav Acha bar Yaakov said, it serves to exclude one who plays with dice who is disqualified as a witness by rabbinic law. The Gemara notes, according to the one who says that the Mishnah excludes one who plays with dice on the oath of testimony, all the more so should a king be excluded as he does not testify by Torah law. And according to the one who says that the Mishnah excludes a king from the oath of testimony, it may exclude only a king, but perhaps one who plays with dice is not excluded, as by Torah law he is fit to testify, and it is the sages who disqualified him. Therefore, he is not excluded from the oath of testimony, which is by Torah law. Okay, the Mishnah teaches the oath of testimony is practiced both in the presence of the court and not in the presence of the court. When the potential witness takes the oath on his own, and if the oath is administered by others, he is liable only when he denies in court any knowledge of the incident in question. This is a statement of Rabbi Meir. And the rabbis, the majority, say whether the witness takes the oath on his own or whether the oath is administered by others, he is liable only when he denies in court any knowledge of the incident in question. The Gemara asks, with regard to what do they disagree? The sages said the explanation before Rav Papa. They disagree with regard to the method of derivation by means of a verbal analogy. Is the method to infer the halacha from the source of the verbal analogy and derive the details from the source as well? Or is the method to infer the halacha from it, but interpret the halacha according to its own place? The Gemara elaborates. Rabbi Meir holds, infer from it and derive the details from it. The halacha of the oath of testimony is derived from the halacha of an oath on a deposit. Just as in the case of the oath on a deposit, one who takes the oath on his own is liable. So too in the case of the oath of testimony, one who takes the oath on his own is liable, and derive the details from it. Just as in the case of the oath, on deposit, just as in the case of the oath on deposit, one is liable whether he took the oath in court or he took the oath not in court. So too in the case of the oath of testimony, one is liable whether he took the oath in court or whether he took the oath not in court. And the rabbis hold, infer the halacha from it, but interpret the halacha according to its own place. The halacha of the oath of testimony is derived from the halacha of an oath on deposit. Just as in the case of the oath on deposit, one who takes the oath on his own is liable, so too in the case of the oath on testimony, one who takes the oath on his own is liable. But interpret the halacha according to its own place and derive the details from the halachot of the oath of testimony. Just as in the case of one who was administered an oath by others, if he denies knowledge of the matter in court, yes, he is liable. And if if his denial does not take place in court, no, he is not liable. So too, one who took the oath on his own, if he did so in court, yes, he is liable. And if he did not take the oath in court, no, he is not liable. So Rav Papa said to the rabbis, if the rabbis derive liability for one who takes if the rabbis derive liability for one who takes a oath of testimony on his own by means of a verbal analogy from the oath on a deposit, then everyone agrees, infer from it, and derive the details from it. And even the rabbis would concede that all the halachot of the oath of testimony are derived from the oath on a deposit. Therefore, one is liable for an oath taken on one's own, even outside the court. So rather, this is the reason the rabbis hold that there is no liability for the oath of testimony taken on one's own outside the court. They derive it by means of a fortiori inference from the halachot of the oath of testimony itself as follows. If one who was administered an oath by others is liable, then one takes the oath on his own. Is he not all the more so liable? And from the fact that they derive the halacha by means of a fortiori inference, one is bound by the limitations that restrict that derivation. It is sufficient for the conclusion that emerges from an a fortiori inference to be like its source. Therefore, just as one who is administered an oath by others, if the oath is administered in court, yes, he is liable, and if it is not administered in court, no, he is not liable. So too, one who took the oath on his own before a court, yes, he is liable, and if it is not before a court, no, he is not liable. The rabbis said to Rav Papa, how can you say that it is not with regard to the matter of infer from it and derive the details from it that they disagree? But didn't we learn in the Mishnah with regard to the oath on a deposit? The oath on a deposit is practiced with regard to men and with regard to women, with regard to non-relatives and with regard to relatives, with regard to those fit to testify and with regard to those unfit to testify. The oath on a deposit is practiced both in the presence of the court and not in the presence of the court. When the bailee takes the oath on his own, and if the oath is administered by others, he is not liable until he denies responsibility for the deposit in court. This is the statement of Rabbi Meir. And the rabbis say, whether the bailee takes the oath on his own or whether the oath is administered by others, once he denied the claim concerning the deposit, he is liable. The question arises, from where do the rabbis derive that one who is administered an oath on a deposit by others is liable, given that an oath of that kind is not mentioned in the Torah in the context of an oath on a deposit? Is it not that they derive it from the halachot of the oath of testimony, and conclude from it that it is with regard to the matter of infer from it and derive the details from it that they disagree? The rabbis hold, infer the halacha from it, but interpret the halacha according to its own place. The fact that one is liable for an oath on a deposit is administered by others is derived from the oath of testimony, but one does not derive that one is liable only if that oath is administered in the presence of a court. Rather, the oath on a deposit administered by others is derived from an oath on a deposit taken on one's own. One is liable in both cases for an oath taken not in the presence of the court. Okay, Rav Papa said to the rabbis, from that Mishnah, yes, it is evident that the rabbis and Rabbi Meir disagree with regard to the matter of infer from it and derive the details from it. However, no inference is to be learned from this Mishnah taught with regard to the oath of testimony, as perhaps the rabbis derive their opinion by means of an a fortiori inference. The Mishnah teaches, if one is liable for the act of taking a false oath with intent, the Gemara asks, from where is this matter derived that one is liable to bring a sliding scale offering for taking a false oath of testimony with intent? It is derived as the sages taught. In all of the other cases where one is liable to bring a sliding scale offering, Leviticus 5, 2 through 4, the defiling of the temple or its sacrificial foods and violating an oath on an utterance, it is stated, quote, and it is hidden. But here, with regard to the oath of testimony, it is not stated, and it is hidden, which serves to render one liable for taking the oath intentionally, just as he is liable for taking the oath unwittingly. The Mishnah teaches, and one is liable for an unwitting act of taking a false oath, provided that he takes the oath with intent in terms of the testimony. The Gemara asks, what are the circumstances of the case of an unwitting act of taking a false oath with intent in terms of the testimony? Rav Yehuda says that this is in the case of one who says, I know that taking this false oath that I do not know the relevant information is provided, but I do not know whether or not one is liable to bring an offering for taking that oath. Okay. The Mishnah teaches, but they are not liable for taking the oath if they were unwitting in terms of the testimony alone. If one actually forgot that he knows about the matter, he is exempt from bringing an offering. The Gemara asks, shall we say that we learn in the Mishnah that which Rav said in response to the dispute of Rav Kahana and Rav Asi? The Gemara in 26a cited a dispute between Rav Kahana and Rav Asi with regard to a certain statement of Rav, and each took an oath that his version was accurate. So Rav told them that although the version of one of the Amoraim was not accurate, he is not liable for taking a false oath, as each Amora was convinced that his oath was true. This is not an unwitting oath, rather it is an oath taken unaware. So the Gemara responds, no. Even though we learned this halacha in the Mishnah, Rav's statement that the one who did not cite Rav's statement accurately is exempt was necessary. It may enter your mind to say it is only here, with regard to the oath of testimony, that one is exempt for unwittingly taking a false oath, as quote, it is hidden, is not written concerning it, indicating that in order to be liable, we require that the halachic status of the unwitting oath is similar to that of an intentional oath. That is, he knows that he is taking a false oath, but he does not know that he is liable to bring an offering for doing so. Therefore, one who is unaware that it is a false oath is exempt. But there, in the case of Rav Kahana and Rav Asi, where each took an oath on an utterance, where it is written, quote, and it is hidden, even if it is entirely unwitting, they were totally unaware that the oath was false. One might say that he is liable. Therefore, Rav teaches us that even in the case of an oath on an utterance, one who is unwitting to that extent is exempt. Okay, back to the Mishnah. The Mishnah says, liability to bring a sliding scale offering for taking a false oath of testimony. How so? In a case where the plaintiff said to two individuals, come and testify on my behalf, and they replied, on our oath, we do not know any testimony on your behalf. We do not have any knowledge of the matter you speak of. Or in a case where they said to him, we do not know any testimony on your behalf, and he said to them, I administer an oath to you, and they said, Amen. If it was determined that they lied, these two witnesses are liable. If he administered an oath to them 5 times outside the court, and they came to court and admitted that they had knowledge of the incident in question and testified, they are exempt. But if they denied knowledge of the incident in court as well, they are liable for each and every one of the oaths administered to them outside the court. If he administered an oath to them 5 times before the court and they denied knowledge of the incident, they are liable for taking only one false oath. So Rabbi Shimon said, what is the reason for this ruling? Since once they denied that they had any knowledge of the incident, they can no longer retract that denial and admit that they have knowledge of the matter. Therefore, there was only one oath of testimony, and there is no liability for the remaining oaths. If both of the witnesses denied knowledge of the incident together, both of them are liable. If they denied knowledge one after the other, the first who denied knowledge is liable, the second is exempt. As once the first witness denies knowledge of the incident, the second is an individual witness whose testimony is not decisive. If one of the two witnesses denied knowledge of the incident and the other one admitted that he had knowledge and proceeded to testify, the one who denies knowledge of the incident is liable. If there were two sets of witnesses that took the oath of testimony, the first set denied the knowledge of the matter, and then the second set denied knowledge of the matter. Both of the sets are liable because the testimony can exist with either of them, as even after the first set denies knowledge of the incident, the second remains capable of providing decisive testimony. Back to the Gemara. The Gemara says, Shmuel says, if the witnesses saw the plaintiff pursuing them, and they said to him, for what reason are you pursuing us? On our oath, we do not know any testimony on your behalf. They are exempt until they will hear a demand to testify directly from his mouth. The Gemara asks, what is Shmuel teaching us? We learn this in a Mishnah in 35a. If the plaintiff sent a request for a testimony with his servant, or if the respondent said to the potential witnesses, I administer an oath to you that if you know any testimony on my behalf of the plaintiff, that is my opponent in litigation, you will come and testify on his behalf, and they took a false oath that they have no knowledge of the incident, they are exempt. That is the end of Daf 31. Chag Sameach Lekulam. Chag Sameach. Happy holiday to everybody. Have a wonderful Shavuot. Take care.